Hi, my name is Teresa Towie, and I'm the Programs Coordinator for Strategic Applications International. As the first of 4 modules, this module will answer the question, what is PL280? This module will provide a basic understanding of Public Law 280, its history, and its current applications or effects in PL280 states. Knowing that PL280 has a variety of nuances depending on the state, this module will give a broad overview of PL280 jurisdictions and law enforcement practices aided or encumbered by PL280, and will cover practical applications for better understanding tribal and state rights within the law. The learning objectives are as follows. The participant will have a basic understanding of PL280 and its history. The participant will learn which government, tribal, state, or federal, has jurisdiction in different scenarios. The participant will understand the practical applications of PL280. And the participant will understand his or her role within PL280. Now, please take a few seconds to read through these cartoons, and I'll meet you on slide 5. To get started, we'll define some key terms that will be used throughout this training module. Jurisdiction is the power of a court or government agency to have authority within a certain realm or territory. Civil jurisdiction means that the law violated imposes a fine, incarceration, or restitution. Some states have opted to assume civil jurisdiction, and thus the tribe and the state have concurrent jurisdiction in PL280 states. Criminal jurisdiction means that the law is designed to encompass the authority of the state to act on behalf of the people who deem such actions a violation of the social norm, and to punish those who violate those social norms. For example, underage drinking is a criminal offense, and the state can take action in PL280 states. Regulatory jurisdiction encompasses laws that are established for the purpose of the general welfare and safety of citizens living in an area. These include health and safety, zoning, building, taxation, labor, and animal control. Generally, tribes retain regulatory jurisdiction. Concurrent means shared jurisdiction. Sometimes tribal and state governments in PL280 states have overlapping authority. Trust land is land which is held by the United States for the exclusive use and occupancy of Indian tribes. Now that important key terms have been defined, let's answer the question, what is PL280? Enacted in 1953, PL280, as amended, grants criminal jurisdiction, and in some cases civil jurisdiction, over offenses committed in Indian country to the governments of 6 states, Alaska, California, Minnesota, Nebraska, Oregon, and Wisconsin, except as specified by statute. Thereby, the state government and federal government have concurrent jurisdiction under the General and Major Crimes Acts. PL280 has resulted in 2 key changes. It allowed states to have concurrent jurisdiction with the tribes and the federal government on tribal lands based on the Indian country General Crimes Act, and the Major Crimes Act. It expanded state jurisdiction, thereby limiting federal jurisdiction in Indian country. PL280 authorized the states of Alaska, California, Minnesota, Nebraska, Oregon, and Wisconsin to prosecute most crimes that occurred in Indian country. There are exceptions for a few topic areas and on a few reservations, but unfortunately, the very limited resources were provided for states to expand their jurisdictions, causing funding gaps in law enforcement and judicial management of the new areas. It's important to note that there are several tribes that do not fall under the purview of PL280. Red Lake Band of Chippewa in Minnesota, the Warm Springs Tribe in Oregon, and the Menominee Tribe in Wisconsin. There are two categories of PL280 states. The first are mandatory states, which Congress mandatorily granted criminal jurisdiction of Indian country to. Those are Alaska, California, Minnesota, Nebraska, Oregon, and Wisconsin. The second is optional PL280 states. Between 1953 and 1968, several more states also exercised expanded criminal jurisdiction in Indian country. The optional states are Arizona, Florida, Idaho, Iowa, Montana, Nevada, North Dakota, South Dakota, Utah, and Washington. You'll see those states indicated in this map. PL280 is very much a product of the United States history. The United States started to negotiate treaties with tribal nations after the Declaration of Independence. The first treaty was on September 17, 1778 with the Delaware Nation. The treaty stipulated that neither the Delaware Nation or the U.S. could punish the other without a fair and impartial trial. In 1790, federal prosecution of U.S. citizens on Indian land was granted. And in 1796, the Indian Trade and Intercourse Act was passed, which added penalties for robbery, larceny, trespassing, and murder for whites in Indian Territory. In 1817, the Indian Trade and Intercourse Act was revised, and it expanded federal criminal jurisdiction over Indian lands, and provided that any Indian or person who committed a crime belonging to any tribe be tried and punished in federal or territorial courts. There were two exceptions to this act. First, it did not extend to any offense committed by one Indian against another within any Indian territory. Second, it did not negate contrary criminal jurisdictional arrangements in previous treaties. In 1885, the first piece of legislation that reversed the long-established federal policy allowing tribal self-government in the prosecution of criminal jurisdiction was enacted. This is known as the Federal Major Crimes Act. The act was established in response to the U.S. Supreme Court's decision of Ex parte Crow Dog, in which the court ruled that federal courts did not have jurisdiction over cases already tried in tribal court. In response to that ruling, the Major Crimes Act placed 7 crimes under federal jurisdiction to crimes committed by Indians in Indian Territory. Those major crimes included murder, manslaughter, rape, assault with intent to kill, arson, burglary, and larceny. In 1887, the General Allotment Act was passed, which provided that Indians who were allotted under the act or who had assimilated as a United States citizen were within the jurisdiction of state courts. This brings us to PL280 in 1953. PL280 expanded state criminal and sometimes civil jurisdiction of Indian country. Initially, tribal consent was not required. However, the Civil Rights Act of 1968 revised PL280 to require tribal consent to any future state's assumption of jurisdiction in Indian country. In Oliphant v. Suquamish Indian Tribe, in 1978, the Supreme Court ruled that tribes lacked criminal jurisdiction over non-Indians in Indian country. In 1991, amendments to the Indian Civil Rights Act were made. Durofix allowed for the tribes to have criminal jurisdiction over non-tribal members. In 2010, the Tribal Law and Order Act was passed. This act recognizes tribes' inherent power to exercise criminal jurisdiction over special domestic violence cases, regardless of whether the defendants are Indian or non-Indian. And in 2013, the Violence Against Women's Reauthorization Act was passed. It It was created to improve public safety in Indian country by amending limitations of incarceration in tribal courts from 1 year to 3 years and fines of $5,000 to $15,000. Understood within the historical context of PL280, there are several perspectives of the reasoning behind the law. Here we provide a brief overview of key rationale, but it is also important to understand that the rationale or rationales behind PL280 are complex and intertwined. The first reason for the passage of the law is that tribal law enforcement institutions were considered to be inadequate, and thus Congress enacted PL280 to fill a judiciary gap by requiring states to step in. The House of Representatives originally introduced PL280 as a mechanism for combating tribal crime in California. The Senate eventually expanded the scope of the bill upon finding that the enforcement of law and order among Indians in Indian country had been largely left to Indian groups, which were not adequately organized to perform that function. President Eisenhower also stated that PL280 preserves the basic safeguards against loss of property rights accorded the Indians by federal treaties, agreements, and statutes, and further safeguards the tribal customs and ordinances of the tribes affected when not inconsistent with the general laws of the respective states. A third reason is that PL280 was enacted during an era of Indian termination policy, which was characterized by attempts to assimilate Indians into mainstream American culture. And a fourth explanation is that the federal government wanted to reduce federal expenditures, particularly for tribal law enforcement, and it was able to do so by not providing funding to PL280 states. There are several significant effects of PL280. Prior to PL280, criminal jurisdiction was shared between federal and tribal governments, while state governments had a limited role. PL280 changed the division of authority between federal, state, and tribal governments in Indian country. While the law did not explicitly reduce or expand tribal criminal jurisdiction, the law has had a negative effect in Indian country because it is often misunderstood by each level of government. There are two types of effects of PL280. The first are legal effects. Legally, PL280 extended state criminal jurisdiction and state criminal laws onto Indian reservations. It also eliminated special federal criminal jurisdiction over reservation areas and shifted it to the state. Practically, state, tribal, and federal governments now have concurrent criminal jurisdiction as a result of PL280. Additionally, the federal government decreased financial and technical resources to tribal governments on the basis that states should be providing those resources themselves. Lastly, PL280 has resulted in poorly funded tribal criminal justice systems because of the funding gap from the federal government. The first important way PL280 has been amended since it was enacted in 1953 is through a 1968 amendment that allowed for retrocession. Under this amendment, any state that had previously assumed jurisdiction under PL280 could return all or any measure of its jurisdiction to the federal government by sending a resolution to the Secretary of the Interior. The Secretary then has the choice to accept or reject the return of jurisdiction to the federal government. Retrocession is a long and complex process, sometimes taking 5 years, but several tribes have been granted retrocession. Yakima in Washington State, Omaha of Nebraska, Santee Sioux of Nebraska, Winnebago of Nebraska, and Bois Forte of Minnesota. If granted, retrocession can advance tribal self-governance and tribal sovereignty and improve public safety for the tribes and people. The second important way that PL280 has been amended since it was enacted in 1953 is through the Tribal Law and Order Act of 2010, which allows tribes to petition the federal government to reassume jurisdiction. This may sound kind of similar to retrocession, which we just discussed, but in retrocession, the tribe and the state opt to end the state's PL280 jurisdiction overall, whereas in reassumption from the federal government results in concurrent jurisdiction, which we'll get to in a second. The process for reassumption is as follows. Tribal governments within PL280 jurisdictions may submit a formal request signed by the chief executive or chairman of the tribe to the U.S. Department of Justice, Office of Tribal Justice, to request the federal government to reassume criminal jurisdiction. After meeting with the Office of Tribal Justice, the Executive Office for United States Attorneys, and the FBI, The Deputy Attorney General makes decisions on reassumption requests. Federal, state, local, and tribal entities also have a chance to respond to the request, and if granted, assumption results in concurrent jurisdiction, meaning that the federal, tribal, and state governments may have overlapping authority to enforce criminal laws when federal reassumption is granted. There has been opposition to PL280 from both tribes and states. Many tribes opposed PL280 because they viewed it as a threat to their sovereignty. You will learn more about this in the sovereignty module to follow. Many states opposed PL280 because they did not receive the adequate funding for assuming authority over Indian country. It is also important to understand that PL280 does have several limitations that are relevant for each level of government. At the tribal level, PL280 does not affect trust status of Indian lands. It also does not end the trust relationship or tribal sovereign immunity or exclude Indians in PL280 states from receiving benefits under federal Indian programs. At the state level, there are several limitations. For regulatory laws, states may not apply laws related to environmental control, land use, gambling, and licenses to Indian reservations. States only have law enforcement and civil judicial authority, not regulatory power. States also have limitations with regards to hunting and fishing rights. They do not have the power to legislate on federally guaranteed hunting and fishing rights. The state generally cannot tax on Indian reservations, and sometimes state courts may be excluded from hearing matters that are core to Indian tribes, such as enrollment and certain domestic matters. There are also two key federal limitations that came in the form of later laws. In 1978, the Indian Child Welfare Act gave Indian nations exclusive jurisdiction over certain child custody proceedings involving Indian children. And in 1988, the Indian Gaming Regulatory Act made enforcement of state gaming laws a federal rather than a state responsibility. Now we will review some general guidelines for applying PL280. If the offender is non-Indian and the victim is non-Indian, then state jurisdiction is exclusive of federal and tribal jurisdiction. If the offender is non-Indian and the victim Indian, then a mandatory PL280 state has jurisdiction exclusive of federal and tribal jurisdiction, unless the Attorney General has granted a tribe's request that the federal government reassume concurrent jurisdiction. An optional state and the federal government have concurrent jurisdiction. If the offender is Indian and the victim non-Indian, then a mandatory PL280 state has jurisdiction exclusive of the federal government, but not necessarily of the tribe. An optional state has concurrent jurisdiction with the federal courts. If both the offender and victim are Indian, then a mandatory PL280 state has jurisdiction exclusive of the federal government, but not necessarily of the tribe. An optional state has concurrent jurisdiction with tribal courts for all offenses, and concurrent jurisdiction with the federal courts for those listed in this U.S. Code. If the offender is non-Indian, and there is no victim, then state jurisdiction is exclusive, although federal jurisdiction may attach in an optional state if impact on individual Indian or tribal interest is clear. If the offender is Indian, and there is no victim, then state jurisdiction is exclusive, although federal jurisdiction may attach in an optional state if impact on individual Indian or tribal interest is clear. In order to understand some practical applications of PL280, we'll review some different scenarios in different states. Scenario 1. In Nebraska, a mandatory PL280 state, a member of a tribe is driving on a highway in an Indian reservation. He kills a woman while operating the vehicle. Since Nebraska is a mandatory PL280 state and manslaughter is a criminal offense, the state has jurisdiction. Because in mandatory PL280 states, the state has criminal jurisdiction even for major crimes. Scenario 2. In South Dakota, an optional PL280 state, a member of a tribe is driving on a highway in an Indian reservation. He kills a woman while operating the vehicle. Since South Dakota is an optional PL280 state, the federal government has jurisdiction because manslaughter is a major crime and the Major Crimes Act is still in effect in optional PL280 states. Scenario 3. In Oregon, a member of a tribe gets pulled over for exceeding the speed limit on her reservation. Oregon is a mandatory PL280 state, and the speed limit violation is a civil regulatory offense. Thus, the tribal government retains jurisdiction over regulatory matters for members of their tribe. Scenario 4. In Minnesota, a teenage member of a tribe gets in trouble for underage drinking at a party. Minnesota is a mandatory PL280 state, and underage drinking is a criminal offense. Thus, the state has jurisdiction. Due to the existence of concurrent jurisdiction between tribes in the state and PL280 states, it is important that different governing bodies collaborate and communicate. State police, tribal police, and sheriff's departments need to create working relationships, which can help establish shared information resources. For example, Prairie Island Reservation has a tag reader that recognizes any tag associated with a warrant. If such a vehicle enters the reservation, the local police are alerted. Tribal police could also be trained at state training posts so that all officers have the same qualifications. And multi-jurisdictional policing allows for better communication about crimes that extend beyond tribal boundaries. In the Task Force Development module, you will learn more about foundational problems that occur at tribal, state, county, municipal, and federal levels, and how to create task forces to respond to those problems. So what is your role in PL280? PL280 is nuanced and can be confusing to understand. Thus, it is important that you do your part to be knowledgeable and flexible with regard to the law. One thing you can do is maintain open lines of communication between tribal and non-tribal police. You can also be educated about local tribes' traditions and practices to better understand tribal resources. For example, a tribe might have substance abuse resources that the state government is not aware of. You can advocate for equal pay and resources for tribal police. Tribes can consider including cadet programs in their high school education system. And you can apply for federal grants through the COPS office in the Department of Justice to support training, development, and tribal policing. In conclusion, PL280 grants criminal and at times civil jurisdiction over offenses committed in Indian country to the governments of 6 states: Alaska, California, Minnesota, Nebraska, Oregon, and Wisconsin, except as specified by statute. Thereby, the state government and federal government have concurrent jurisdiction under the General and Major Crimes Acts. Between 1953 and 1968, several more states also exercised expanded criminal jurisdiction in Indian country. These optional states are Arizona, Florida, Idaho, Iowa, Montana, Nevada, North Dakota, South Dakota, Utah, and Washington. PL280 is nuanced and has been interpreted in different ways by different states. Thus, a key takeaway is that you should be knowledgeable about PL280 in your state. With collaboration and communication, PL280 can serve as a benefit to sheriff's departments and tribal police departments by fostering a law enforcement community based on resource sharing and cooperation.